Okay, good morning, everyone. Members and guests of our Family Business Learning Community. I'm Sally Durstine, and I'm delighted to welcome you to our second webinar that is focused on helping business owners navigate COVID and all that this means to us. So we are all in new terrain here, and we are committed to surrounding you and to helping you move through this. We are really grateful that we can be connected through technology. We prefer face-to-face, but this is a good second. And I've also been really inspired by hearing your stories over the past few weeks and how you are living out your values of generosity and caring for the common good at this time. And a reminder to also do some self-care, really, really important. So just a few housekeeping notes. We will be recording this, and you can access that on our website later on. Beth will send an email out with those links of both the audio and the video. Also, Ethan and John's handout will be available on our website. You can ask questions, and Jared, would you please talk about how they can do that?
So if you're on a tablet, the main thing, if you're on a tablet or your phone, you may not see the menu, but if you touch at the top or bottom of your screen, a menu will drop down and it says Q&A, and there's a big Q there. That's where you want to ask your questions. And if you're on a laptop, that bar should be at the bottom of your screen all the time, or on a desktop. But click that, ask the questions there, because that helps us keep track of where they are. We may or may not get to all of the questions, so apologies for that, but Sally will be moderating that and asking the questions as we go. So feel free to ask the questions there. If you have a technical question, you can ask that there as well, and I'll respond to you privately through the Q&A function. So it won't be aired live if you have a technical question, but I'll be able to help you out there, or try.
Thanks, Jared. So today we're going to focus on what every family business needs to know about paid leave. Now, family businesses are known for taking care of their people, of their teams, thinking long-term. Retention rates are often very high. So the people issues are the most difficult. And what makes it more compounding is that many of you are in different roles. You're a family member, you might be a board member, a shareholder, and also in management. So you probably have some conflicted feelings as you're moving through these important decisions. So here to help us are two fine gentlemen from Hamburg, Rubin, Mullen, Maxwell, and Lupin in Lansdale. They've been educational sponsors of ours since near the beginning, about 30 years. We really like and trust these guys. Ethan is going to be speaking first. Ethan chairs their firm's employment law group, and his practice focuses on employment law, commercial litigation, real estate litigation, and criminal law. So Ethan counsels corporate and individual clients on a variety of these issues. And then John, you probably know the best. Both have made many presentations and worked with many of you. He chairs their business and estates department. And John combines his practical experience in business law and estate planning with detailed knowledge of the tax law. I often call John the defense coordinator. So we are just delighted to have them give input, and I'm going to turn it over to Ethan to start us off.
Thank you, Sally, and good morning, everyone. I've met some of you. I've not met all of you, so it's a pleasure to meet those I've not met previously remotely, if this counts as such a meeting. Perhaps we'll get to meet in person under better circumstances one day. Thanks for joining us. John and I are happy to be here. We're members of our business advisory group, and it's our hope always to help our business clients grow and prosper. And now more than ever, we're helping clients get through this as best we can as we try to get through it ourselves. As most of you know, if not all of you by now, Congress has recently passed some sweeping legislation, passed very hurriedly to try to help businesses, families, individuals get through this crisis, however long it's going to last. And they passed on March 18th what's known as the Families First Coronavirus Response Act, or FFCRA. And forgive me if you're actually watching as I speak as opposed to listening. If you see me glancing off to the side, it's a first webinar for me as a presenter, and some of my materials are off to the side here. But this Family First Act went into effect yesterday. so the timing of this seminar is very good this morning. It applies to private employers with less than 500 employees. I can't tell you where that number came from or why, but that's what these laws will apply to, which is probably everybody who's attending today, unless there are one or two with very, very large companies they have. It has two components to it, this new law. One is an expansion of the existing Family Medical Leave Act, called the Emergency Family Medical Leave Expansion Act. And the second component is the Emergency Paid Sick Leave Act. And the two work hand in hand, at least they were designed to work hand in hand. We'll see if they truly do as this moves forward and everybody figures it out together. But generally, it's providing employees who are going to be out for what I'll call corona-related reasons with a period of paid sick leave. It's going to be 2 weeks of paid sick leave if they have a health condition related to corona, or they have a household member or caring for somebody with a corona-related condition, or up to 12 weeks of paid leave for childcare, because school and daycare and such things are closed right now. And about 10 days after this Family First Act was passed, just a few days ago, Congress enacted and Trump signed into law what we call the CARES Act, or the Coronavirus Aid, Relief, and Economic Security Act. And among many things, and John will touch on some of them with regard to tax credits, business loans, et cetera, it also provides some pretty sweeping expansion of unemployment compensation rights. And that will be a factor in what employers and employees do over the next several weeks, and hopefully not several months. So we're going to talk about all of that today, how they relate with one another. And of course, layered on top of all of that is our governor's order closing businesses across Pennsylvania, and the stay-at-home order, including some businesses from operating at all. Others are operating at part staff. Some employees can go to work and some employees are not supposed to go to work. And we'll talk about it all this morning. So let's start with the FMLA provisions, this expanded FMLA Act under the Families First Act. Some of you, in fact, perhaps many of you, never had to worry about the FMLA before because it only applied to employers with more than 50 employees. So if you're a very small employer with less than 50, you are not a covered employer under the FMLA. Well, welcome to the party, because you're now covered for these limited reasons in this expanded emergency FMLA Act. Basically, what Congress did was expand the employees who would be eligible for leave to include workers who have children home from school or whose daycare is no longer available because of the corona epidemic. They amended the law to provide paid leave as opposed to unpaid leave to those workers if they need to care for a child, and we'll get into that a little bit more specifically. Previously, the FMLA only provided for unpaid leave up to 12 weeks for a serious health condition of yourself, a family member, or for the birth of a child, and one or two other reasons that we don't need to talk about, but that was unpaid. It was simply a job protection statute. That has changed, and there's now a paid component. We'll get a little bit more specific about it. There's also a change in this regard with the eligibility. Under the regular FMLA, the employee had to be employed for a full year and work a certain number of hours before that employee would be entitled to take leave. That has changed. Congress has made it available to many, many more employees. So the general rule of thumb, it is now only a 30-day employment requirement. So if the employee is employed for at least 30 days, that employee is now eligible for FMLA leave. I see up on the screen an outline Jared has been good enough to put up. We prepared some materials. I think Jared will scroll through it a little bit. You are free to look at this as we go. You're free to ignore it. You can print it out later. It's fairly comprehensive. There are one or two edits I'll have to kind of go through verbally, because after I prepared this around the lunch hour yesterday, Congress is good enough to enact regulations of over 100 pages late yesterday afternoon. So in its haste to put this through, Congress enacted it April 1st, or made it effective April 1st. And now on April 2nd, we have regulations interpreting it. And as I'll touch on, the Department of Labor took some liberties in interpreting the strict language of the law. But let me continue now. So you see on screen the general rule of eligibility. The general rule was the only rule when this law was first enacted about 10 days ago. When the CARES Act came out a few days after that, Congress amended the eligibility, and that's why you have this second section, this little double I, the rule regarding rehired employees. That is new. And it's interesting because, frankly, I wasn't quite sure what it was intended to cover. The regulations that I looked at last night helped that a little bit. But you can see that it says an eligible employee includes an employee who was laid off by the employer not earlier than March 1st of this year and had worked for not less than 30 of the last 60 calendar days and was rehired by the employer. And that's the catch in this one. It is designed to cover folks who may have been let off last month, but then come back to work. So if an employee was laid off at March 15th, assuming that employee had worked for 30 days, but now comes back to work, say May 15th, hopefully we're all back to work regularly by then, that employee is now going to be eligible for this FMLA leave. The employee wouldn't have been receiving the FMLA paid leave while he was laid off or she was laid off, but of course may have been eligible for unemployment during that time. But now when they return, they're going to be immediately eligible. In my mind, it raises an interesting issue and perhaps an unintended consequence, because I suspect that there may be some employers who are not going to be inclined to bring somebody back that could be eligible to return if they know that that employee is immediately eligible to take paid FMLA leave. But that remains to be seen, and in any event, that employee is now going to be eligible. As the statute was written, it indicated, as you can see below the eligibility, that the FMLA leave would be for a qualifying need related to a public health emergency. We're now in a public health emergency, meaning that the employee is unable to work or telework, and that's important, due to a need for leave to care for the son or daughter under 18 years of age. The Department of Labor stepped in and modified the under 18 years of age. It's been expanded. So if there is a child or a person 18 or above in the household that's disabled, a special needs person, the employee is able to take paid leave off to care for that person. So if there's, say, a college age person or a 22-year-old that has special needs, as long as it's a son or daughter of the employee, that employee is still going to be able to take paid leave. And it was a little funny reading the regulations, where the department in those regulations made a point of saying, yeah, we know what Congress wrote, but we don't like that very much. So we're going to interpret it a little bit differently. And that was one of those provisions. So with regard to paid leave, how much is it going to be? As I see the screen scroll, thank you, Jared. It's going to be unpaid for the first 2 weeks of the person's leave. Now, it technically says 10 days, but that could have led to inconsistencies with the Sick Leave Act. So again, in the regulations, the Department of Labor said, yeah, forget about 10 days. They kind of meant 2 weeks, so we're going to call it 2 weeks. But in any event, the first 2 weeks are technically unpaid under the FMLA, but we'll talk about that in a minute, because if somebody's taking sick leave for the same thing, it can be paid. And of course, the employee can always substitute their own PTO to have those first 2 weeks of leave paid. This emergency FMLA leave is going to be paid at 2/3 the regular rate of the employee. So it's not full pay, It's 2/3 pay, but it's capped. A maximum of 200 per day or 10,000 in the aggregate. So if you have a very highly paid employee who's out on FMLA, that employee isn't going to get a straight 2/3. There is a cap of 200 a day or 10,000 for these 10 weeks. And I say 10 weeks because the first 2 weeks are technically unpaid of FMLA. If you've got a relatively new employee and that employee has irregular hours, basically you're going to be looking at the last 6 months to figure out the average weekly hours and pay accordingly. There can also be intermittent leave for this paid leave. There's no intermittent leave if there's going to be sick leave because of somebody's own illness, but if somebody is out caring for a child, the leave could be intermittent. For instance, they might have child care 3 days a week, but not 2 days a week. So therefore, they could get their FMLA leave on those 2 days a week. An interesting scenario that's come up for me is I've talked to some business clients over the past week or two is what if there are 2 parents home and daycare is closed, but they both work, both their offices are open. Now, do they have somebody else to watch the kid or not? And I think all we can say is that the employers on both sides are going to have to be flexible, maybe 1 week on, 1 week off or something like that. But the employee also has to have a need for the leave. So if the employee has another responsible adult at home who can watch the child, that employee doesn't have a need for the leave, and the regulations make that clear. So this is not meant to be a vacation to spend some quality time watching movies at home with the children if there's somebody else to watch them. Again, the family medical leave is a job protection statute, and that applies in this case too. Normally under the FMLA, if somebody's out, they're entitled to return to their same or equivalent position at the same rate of pay once their leave is finished. That applies to this new act also, but there is an exception for very small employers. If you're an employer that has less than 25 employees, the job protection aspect of this doesn't apply, meaning you don't have to bring an employee back. However, there's a catch, certain conditions attached to that. You don't have to bring the employee back if basically because of this epidemic and the business slowdown and a change of economic conditions, the job is no longer available. So they basically are saying, bring back the employee unless you can't. And if you can't, you still have to try. So within the next year, if a position becomes available, you've got to bring that person back. Otherwise, these very small employers are going to be exempt. Speaking of exemptions, we move on to our next section in the outline. This provision, this expanded FMLA Act, is not going to apply to absolutely all private employers. There are exclusions for healthcare providers and emergency responders. So if you're in a physician's office, you don't have to give paid leave to your nurses and other people who work in your office. And healthcare providers is pretty broad. It doesn't have to be a doctor or nurse in the office. Employees of healthcare providers are going to be exempted from this act, unless, of course, the employer allows the leave, which is certainly okay. In order, however, to be exempt, the employer is going to have to show certain conditions. The language in the act is that you can be exempt if you're under 50 employees in your company if the employee's leave would, quote, jeopardize the viability of the business as a going concern, close quote. And nobody really knew what that meant. However, a couple of days ago, and is confirmed in the regulations last night, the Department of Labor has provided a little guidance, and the employer is going to have to show one of 3 factors, which I've listed in this outline, in order not to grant paid leave to its employees. The first one would be that allowing the paid leave would result in the small business's expense and financial obligations exceeding available business revenues, causing the business to cease operating at a minimal capacity. Now, that's a pretty onerous showing. And it basically says if you let somebody go on paid leave, it's going to put you out of business or close to. And in that dire circumstance, you can deny the paid leave. The second factor you might be able to show is if the employee risks the financial health of your company because that employee has specialized skills, knowledge of the business, or responsibilities. So basically, if it's such a key employee and you can't do without that person, you might be able to deny that person leave. And the last reason is basically if you can't find people to replace the employee and you can't operate at a minimal capacity. So it's a pretty difficult showing that a small business is going to have to make in order to not comply with this paid leave provision. You're going to have to document it. In fact, the regulations speak to documentation. So if you are the business owner or the business manager, make sure you have documentation that justifies why the leave won't be paid. You're not going to be required to get any kind of waiver or submit any materials directly to the Department of Labor, but you are required to keep the documents in case this is challenged at some point. Typically, if there's a violation of the FMLA, the employer can be sued by the aggrieved employee. That's not the case for small employers with this expanded act, but that still doesn't get you off the hook. It's not that you can violate the law with impunity. The Department of Labor can still come after you. So while I suppose that that's less likely, you still don't want to get that call. So if you have any questions with regard to your obligations under the Family Medical Leave Law, check the website of the DOL, check with your HR folks, call me or some other employment lawyer, and just be careful you're doing what needs to be done. Just checking time here, and I think we're doing okay. So the second component of the Families First Act is the Emergency Paid Sick Act, or what we call the Sick Leave Act. In most jurisdictions, Pennsylvania including, employers are not required under the law to provide paid sick leave. Many do, whether it's a combined PTO thrown in with vacation or a specific amount of sick days, but the law doesn't require that, neither federal or state law. Well, it does now. There's going to be a 2-week paid sick leave provision for corona-related reasons. And all of your employees are eligible. It doesn't matter how long they've been employed by you. If you hired them last week, they're eligible for paid sick leave as of yesterday. Now, it has 6 components to that. There's 6 scenarios in which an employee is now going to be entitled to paid sick leave. One is that they're subject to a quarantine. And, well, we're all now subject to a quarantine, virtually all of us anyway, whose businesses are closed unless we can work remotely, like John and I have been doing, and I'm sure some of you have been doing also. The second reason, if the employee has been advised by a healthcare provider to self-quarantine. So if somebody has supposedly symptoms of the virus and talks to a doctor, and a doctor or nurse says, stay home, quarantine yourself, they're now eligible for the 2-week paid sick leave. And that's kind of hand in hand with the third reason, if they're experiencing symptoms and seeking a medical diagnosis. So the first 3 reasons where an employee can have the 2 weeks of paid sick leave under this new act deals with the employee's personal circumstances. If they themselves are subject to the quarantine, or they themselves are sick or seeking medical treatment. The next 3 reasons deal with other folks. For instance, number 4 is the employee is caring for an individual subject to quarantine. Typically, that's a direct family member or somebody in the household. Although the regulations, if I read them correctly, seem to indicate if you're caring for just a roommate in your home, that might be enough. So it doesn't specify only immediate family members. And the fifth, and this is where the FMLA comes into the play, the fifth reason for sick leave is if your child needs care because school or daycare is closed. We'll talk about that more in a minute, but these two were meant to go hand in hand, but that's a reason for paid sick leave. And then the sixth, and this is a little odd, the employee is experiencing any other substantially similar conditions specified by Health and Human Services. I'd like to talk about that more, but I can't because I don't really know what it's intended to serve. I didn't bother looking at the regulations for that, but I don't think that's going to come up. The first five are what we're going to deal with. Like the FMLA provisions, there are exemptions for healthcare providers. Now, if you go down to the next paragraph, Jared, can we scroll a little bit more? That'd be fine. I was a little imprecise in the materials I wrote, and I just want to make sure nobody leaves with a misimpression, because I indicate that small businesses, again, under 50 may be exempt from the Sick Leave Act's requirements, but that's only partially true. This provision only applies with regard to the sick leave needed to care for a child home from school or without daycare, et cetera. There is no exemption for small business if the employee is suffering corona symptoms or a household member is suffering corona symptoms. The 2-week sick pay in those situations are mandatory. The only exemption for paid leave is basically for small employers when the employee needs leave to care for a child who doesn't have daycare. Now, as far as the duration, full-time employees are defined by this Sick Leave Act as employees working for 40 hours a week. But of course, a lot of you have what you consider full-time employees, forgive me, that may work only 37 and a half hours a week, 35 hours a week, and that's fine. That doesn't mean they're not entitled to leave. But an employee working 36 hours a week doesn't get 80 hours of paid leave. Basically, the employee is getting 2 weeks of paid leave for the regular hours that they would have worked in those 2 weeks. So if I work 20 hours a week, I'm going to get 40 hours of paid sick time. But there's a cap to this too. It's $511 per day or $5,110 in the aggregate. And that's for the person's own sick leave, reasons 1 through 3 in that list of 6. If a person needs to take 2 weeks of paid leave off to care for somebody else or because of childcare reasons, that's going to be $200 a day or $2,000 in the aggregate capped. And if it's your own leave, you get your full pay. If it's to care for somebody else, you get 2/3 pay. And that is consistent with the family medical leave, which again is only for child care. Speaking of which, let's talk about how they work hand in hand. So if I have a child home from school because schools have been closed by the governor and I have nobody else who can care for the child, I can now take leave for a total of 12 weeks. My first 2 weeks are going to be paid under the Sick Leave Act at 2/3 pay. And the next 10 weeks are going to be paid under the expanded FMLA Act at 2/3 pay. So anybody with childcare is not going to go without pay. And you can't make the employee use any available PTO simultaneously with those first 2 weeks of new emergency sick leave pay. The emergency sick leave pay comes first. There are notice provisions. There's now a poster that's available, and employees are entitled to notice, and employers are required to provide notice by posting a poster. The link to the site at the DOL where you can find the poster, if you haven't seen it already or received emails about it, is here in these materials. You can download it for free, but it's got to go up in the break rooms. The Department of Labor talks about notifying employees who might be out of work about their rights and so forth, but I have not seen anything requiring you to take those affirmative steps. It seems that all that's really necessary is to put the poster up. Bear with me 1 second, because I think I got ahead of myself from the outline and spoke about the next paragraph already. I don't know that I need to cover it any further. No, I think we're good. The Department of Labor has a pretty good website currently through its wage and hour division. And there are a lot of useful pieces of information, including a good Q&A for common questions about the FMLA or Paid Sick Leave Act and their interactions and who's subject to it and who's not. So if you want to read the specifics, you're certainly free to go onto that website. Now, in conjunction with the passage of these laws, both in these laws themselves and later in the CARES Act, Congress gave some businesses that were going to be impacted by this new mandatory paid leave a little bit of help with tax credits and such. So now I'm going to turn it over to John, who's going to touch on some of those areas. Sally?
Well, maybe before we do that, let's take a few questions. We have some good ones here.
Sure.
So one participant wants to just confirm that if you believe your company qualifies as exempt in regard to denying paid leave, if you have under 50 employees, you do not need to file a formal appeal. Just hold on to the documentation in the event that you're questioned.
Correct. If you're a small employee and you think you are exempt from allowing paid leave, you don't need to file any kind of waiver. And it sounds to me like somebody's asking because there were certain waivers had to be filed if you wanted to stay open under the business closure in Pennsylvania. So it's not like that at all.
And secondly, if there's intermittent leave for childcare and the employee misses 2 days per week, does that count as 1 week? Or is it a total number of days that they are eligible for, as in 10 weeks times 5 days?
It doesn't count as a week. This isn't different from the regular FMLA. So it's basically 12 weeks times as many hours of leave. So for instance, forgetting about this expanded act under regular FMLA, if somebody had intermittent health problems, flare-ups, they could take a day here, a day there. They could take doctor's visits. They might need a week to recover from a procedure, then 3 months later, another week to recover from a procedure. And that's perfectly okay. And that's going to be okay here also.
So how about, Ethan, if you have an employee whose time off predates the 4/1/2020 effective date, how would they determine compensation, and will they receive tax benefits if they paid them for that time?
The law is not retroactive. The effective date is April 1, and people who are out before April 1 are not entitled to retroactive paid leave. I'm not sure if this is where the question is going, but if somebody had already used, for example, 4 weeks of FMLA leave for their own serious health condition, for instance, they had a medical procedure, an operation, and were out the month of January, that employee doesn't get an additional 12 weeks of leave to look after the child. You only have 12 weeks total. So they've already used 4. Now there's 8 weeks of leave available. And that applies on the other end too. If you use 12 weeks of paid leave now, maybe April, May, June, to look after the child, and then you've got something that comes up for yourself in October of this year, you don't have any more FMLA leave available. I hope I answered that person's questions. If not, please contact me directly after this is over and we can talk through it.
So Ethan, what if we have over 50 FTE employees before the layoff?
I'm not sure I understand the question. You have.
So some of the things were for 50 50 employees and less?
Well, the exemptions can be for 50 employees and less, but if you've got over 50 and less than 500, you're not going to be exempt. There's no out. You're going to have to pay the family medical leave.
Oh, okay. And
Jared, I think, had something to say in that regard.
Well, I think the question is, what if you were above 50 before, then you laid people off and now you're under 50? Are you exempt or not?
Oh, are you now a small employer?
yeah.
That's a good question. I think it's at the time the leave is requested. Now, this might be important as to whether you've laid people off or just furloughed them, because a furlough is not a layoff. It's just an unpaid employee situation. And there's an awful lot of furloughs right now in many instances, so employees could still be on the employer's health plan. So they haven't been technically terminated and they're still going to be on payroll. But if there's been formal layoffs and you're now a small business, you probably could qualify for the exemption. Thanks, Jared.
Thank you. We're good.
All right, John's going to tell us everything we ever wanted to know about tax credits and loans because of this disaster.
Good morning, everyone. I hope everyone is staying safe and is in good health. I have some good news. Government, as far as I can see, is going to end up paying for this leave, not the employer, because the law provides for something called tax credits. The bottom line is that the IRS is getting involved, and we're turning to finding a source for paying the leave. And what that's pointing to is the withholding tax that the employer takes from the employee. So the withholding tax is income tax, Social Security tax, and Medicare tax. In normal conditions, you as an employer have to withhold that from the employee's pay, and then you're bound to deposit it with the IRS on a quarterly basis. But when you withhold it, before you deposit it, there's cash there. And in normal conditions, if you do not turn that over to the IRS, you're going to have a real problem because they're going to come after you personally. But things are turned on their head now, and the solution for paying for this, at least the partial solution, is to let the employer use the tax deposit money to pay the leave. So let me go back and talk that through. So there's a tax credit technically, and here's how they calculate the tax credit. The tax credit is the actual leave money you're paying out to employees who are on leave under this law. And we're talking about both the sick leave pay and the family leave pay, both of them. Plus, you're keeping these employees on your health insurance, so that the cost of maintaining the health insurance for the employees on leave is added on. That's also part of the tax credit. And so the way that the employment taxes work is the employer, on the employer side, when you're paying leave out under normal, or paying wages out under normal conditions, the employer has to pay employment tax. However, this law says that another part of the credit is the employment tax the employer normally would have to pay. So let me explain a little bit more. The employer part of the tax is Social Security and Medicare. So the way that employment taxes work is you withhold the income tax, but you also withhold the employee's part of the Social Security tax, which is 6.2% rate, and the employee's part of the 1.45% Medicare tax. Also, on the employer side, you also have to normally pay 6.2 Social Security tax and 1.54 Social Security Medicare tax. So let me talk about that. The employer's Social Security part 6.2 is totally inapplicable to this leave. The CARES Act said that when you pay these leave payments out, the employer has no obligation to pay the 0.2, but the employer still has the obligation to pay the 1.45. So I'm getting in the weeds here a little bit, but the tax credit has three components: the actual leave you're paying out, the health insurance expense relating to these employees during the leave, and the employer's 1.45% Medicare tax. So this is technical, but the idea is to make you whole for paying this leave. So you have this credit. So now you can take what you've withheld from the employees, which is their income tax withholding. And I'm talking about all employees here now. So you're withholding for income tax for the employees' Social Security tax, and for the employees' Medicare tax. Those deposits that you would normally turn over to the IRS, you can use that cash flow to pay the leave, to pay the health insurance, and to pay the employer's Medicare tax for all these leave payments we're talking about. Okay, so what happens if you pay, you have to pay the leave and it's more than what you have in deposit for the withholding? What happens if you don't have enough cash from your withholding to pay the leave? Well, guess what? The IRS will cut you a check. So this tax credit is technically refundable. You apply for the shortage where you don't have enough deposit from withholding to pay this leave and to pay the health costs and to pay your Medicare unemployment, and you file a form and the IRS hopefully pays you quickly. So on my outline here, I note that Tuesday evening, the IRS issued guidance. This is the IRS now. The Department of Labor issued guidance that Ethan was just talking about yesterday. The day before, they issued guidance about this tax credit. And it's a very comprehensive guidance they issued. It has 6 different questions and answers. So it's really worthwhile to go on there and try to figure out, if you don't understand what I've just been talking about, it really lays it out. And obviously there's paperwork involved here. There's also certain substantiation. So in order to take all this deposit money that you normally would have to turn over to the IRS and use it to pay leave, or audited, because the IRS is involved now. You could get audited by the IRS. You got to have documentation to show that you're paying leave based on all this, what Ethan was just talking about, and that these people were really on leave. And so this IRS guidance provides a number of different things, one of which is what all the substantiation requirements are. And you got to read that. It has the form 7200 that you file if you don't have enough deposit money from the tax withholding and you need the check from the IRS to pay you for the balance. That's the 7200 form. Also, if you're self-employed, if you're a proprietor, or if your company is treated as partnership for tax purposes, where the owners don't get W-2s, the owners have to pay estimated tax and they get profit distributions. If the owners themselves qualify for this leave, the sick leave and the family leave, they can get the benefit of the tax credit in a different way. And you can read about that. Basically, since you don't have withholding because you don't get a W-2, you can get credits on your 1040 income tax return to make you whole. So all this is explained in this really comprehensive IRS guidance. I encourage you to check that out because, like I said, the government's supposed to pay for all this.
Mhm.
Thanks.
Well, John, it's really good to hear the good news. Thank you for distilling all that down into some simple, plain English. Appreciate it.
Thank-
So we have another question here. Ethan, you had mentioned a little bit about the difference between layoff and furlough. So can furloughed employees sign up for unemployment if the company was approved as an essential business, but the employee was furloughed due to reduced income to the business?
For unemployment compensation.
Sorry, you were muted. Could you repeat?
I was muted. Somebody didn't think I was worth listening to, I suppose. Jared. The question was, can a person who is furloughed but the company is still operating apply for unemployment? And the answer to that is a definite yes. That person has lost their job. At least they've lost their income, if not technically been terminated, to no fault of their own, presumably in this situation. And that person can apply for unemployment compensation benefits, which is a perfect segue. I don't know if it was intentional or not, Sally, but a perfect segue into our final topic, which is focusing on unemployment compensation. Part of the stimulus package or the CARES package was some very significant expansion of what otherwise had been accepted unemployment compensation standards and regulations administered through the states for quite some time. The Congress has made many folks eligible for unemployment compensation that weren't eligible before, such as self-employed persons. And they've also made people eligible if their benefits had previously expired. And they've also extended the eligibility up to 39 weeks. But most importantly, I think for most of the people on this seminar today and for most of your employees, is that the Congress has upped the ante for unemployment. They've provided an additional $600 per week unemployment benefit to people who are unemployed, partially unemployed, or unable or unavailable to work for a whole bunch of reasons associated with the coronavirus. And they include a person's illness, quarantine, childcare, business closure, and the one I like, the individual has to quit his or her job as a direct result of COVID-19. Well, that certainly could open the floodgates because that says, well, I thought I had to quit because of whatever. Well, we'll deal with that one day if we have to. But basically, any reason associated with COVID-19 that prevents somebody from working, that person's now going to be able to get, in addition to regular unemployment benefits, an additional $600 per week in compensation benefits. Now that $600 a week in supplemental benefits goes through July 31. So somebody who's lost their job or has lost hours and can only get partial benefits in Pennsylvania through July 31 is going to be able to receive what they would have received 2 months ago in regular compensation benefits. And on top of that, another $600 a week in compensation benefits. So I think the intent was to make folks whole through this crisis. In actuality, some people who were not making a ton of money, typically under $60,000 or so, may actually make more money on unemployment than they were making while working full time, and that's just the reality of what this package has done. Now, a person cannot get unemployment benefits if they're able to work remotely, nor are they going to be getting benefits if they're already getting paid leave. So if somebody's getting paid family medical leave, paid sick leave, paid time off, they're not going to be getting benefits for those weeks. But if they don't have a source of income, if they lost hours or they've lost their job entirely because of COVID-19, this new unemployment package applies. So Congress in its haste has tried to do whatever it could to keep things going, to keep people out of the poorhouse, so to speak. But it certainly created a lot of confusion, a lot of questions, and in my opinion, a lot of unintended consequences, some good, some not so good. One thing I don't think I mentioned that I want to indicate before we kind of break and take any other questions we might have is that if the person has lost their job, whether it was in March or 2 weeks from now, they're not going to be entitled to this paid leave under the Paid Sick Leave Act or the Family Medical Leave Act. If somebody was going to lose their job anyway, because of quarantine, they come down with the virus, the business is closed, they're not going to be eligible for the benefits, the paid leave benefits. Rather, they'll be getting unemployment benefits in those scenarios. So unless John has anything directly he wanted to add, I don't have anything further. Again, with regard to unemployment, the State Unemployment Compensation Office has a very good website answering most folks' questions for both employers and employees. And I've put that link toward the bottom of this section. I've also included the email and office direct telephone numbers for myself and for John if anybody wants to contact us directly. So Sally, I don't know if there's any other questions. Jared has a question.
Do you have a question, Jared?
Yeah, it says there unemployment or partial employment, and I always pick up on kind of the ambiguous language, and I know a lot of people are reducing hours. Can you say more on what does partial employment mean?
If you've lost hours because you used to be working 40 hours a week and now you're only working 20 hours a week because the employer just doesn't have those hours for you during this economic slowdown, you can apply for what we call partial unemployment compensation. The way the unemployment system works in Pennsylvania, and each state's a little different. You get unemployment based on how much you were earning and how many hours you were working. The maximum weekly benefit is $572 an hour. So if somebody was making basically over $75,000, they're going to be capped at 572, but now they're going to get an extra 600 through Congress. Rule of thumb, if you're making under that, you get in regular benefits about 50% of your weekly salary, your weekly gross, in unemployment. So if I was earning $1,000 a week, my unemployment for full benefits is going to be $500. If I'm now working, a half week, 20 hours a week, I'm not going to get $500. I'm going to get a lesser amount. That's what we call partial benefits. And there's kind of a funky formula that the Compensation Bureau uses to determine what that partial benefit's going to be. But the way we were reading this law is if you're getting any benefits at all, full or partial, you're going to get the new $600 bump through the stimulus package.
Okay, so Ethan, and was that good enough, Jared? That's fun. So a few more questions here. What happens if the employee is able to work remotely, but they were furloughed due to reduced income to the business?
Then they're not working. If you're working remotely, you don't get unemployment and you don't get paid leave. But if you can't even work remotely due to circumstances which won't even allow you to do that, or you're actually furloughed and the employer doesn't want you working remotely, now you're eligible for benefits. Now you're truly out of work.
Okay, Ethan, is there a specific amount of time an individual would need to be employed out of business in order to qualify for this unemployment compensation expansion?
The regulations for unemployment, and I don't want to talk out of turn because I can't speak to this with great expertise, but you have to have a certain amount of quarters and income to apply generally. So if you just turned 18 and you got your first job and you worked for a day and then were laid off, I don't think you're going to be getting as much as, John or I would be getting if we're suddenly out of work, if you're eligible for anything at all.
Here's an interesting one. Do lost overtime hours qualify for lost hours?
I don't believe so, but that's the best I can say.
Okay. Do the additional UC benefits, $600 per week, apply to employees who are laid off but promised to be rehired?
Yeah, that's a furlough situation. Well, no, that's not a furlough situation. They've been truly laid off. Yes, because they're out of work.
Yes, okay. Could you clarify whether the responsibility is on the employee to file a claim for paid sick leave or the employer to offer it to employees?
Well, that's where the notice comes in. There's no application process like you're applying for unemployment benefits. It's just a mandatory benefit. So it's something that the employer has to give.
Okay, thanks. What reduction of hours qualifies for partial unemployment? For example, if an employer reduces hours by 10%, can they apply?
You can always apply. You're probably not going to get it at 10%. I did some calculations under different scenarios for a client. And a few minutes ago, I indicated there was a formula which you base it off of what your full benefits would be and then what your reduction of hours is. So that indicates how much you're now making. So it's an if. It depends how much you're working. But I'd be very surprised if somebody with such a minimal reduction would be eligible for even a partial benefit.
Okay. If an employee would normally get $500 in unemployment compensation, will they now get an additional $600, bringing them to $1,100 in total unemployment?
That's my understanding. And that's why it seems, and you've heard some commentators on TV and radio say that it's kind of crazy that some people could be doing just as well for not working as they were when they were working. John, I think, wants to speak up to that.
I have a question. Isn't this $600 only for 4 months or 4 weeks or no, 4 months? There's a limitation of it.
Right, July 31.
Okay, thanks.
Okay, Ethan, how about an employee working 38 hours? Do they get the 600?
As long as they've been laid off, furloughed, had their hours sufficiently cut that they can apply for benefits. Even part-time employees, if they've lost work, if they've lost their job, can apply for benefits. Unemployment is available to part-time employees.
Okay, these are great questions. If the business is closed due to being non-essential, can the employee file for paid sick leave?
No, because that employee wouldn't be working anyway, and that's where comp comes in.
Okay, we got all the questions answered.
Well, hopefully I answered them correctly.
And this is great timing because we have 2 minutes left and really want to thank you, Ethan and John, for your expertise and staying up and staying on top of this. I know you guys are trying to keep up with all these changes. And also want everyone to know that we are going to have this on the website later this afternoon, as well as the document. We are continuing the webinar series. We have 2 next week. On Tuesday, April 7, we'll be talking about what's up with the stock market and my retirement plan. You know, some of us have been crazy watching it plummet and other people are really excited. So what does all this mean? And then Thursday, April 9, we're going to be responding to your COVID-related family business questions. So it's going to be like kind of an open mic. And who knows where we'll be there, probably a whole new set of questions. So thank you again, Ethan and John and everyone for joining us. And we look forward to seeing you Tuesday or give us a call before then. So long.
Thank you, everybody.